Due Process, recipient of 6 Mid-Atlantic Emmy Awards.
Beginning of my 8th grade year, a choir master came to the school who molested me multiple times every day during the course of that school year.
A unique, respected boarding school where boys study and sing to national acclaim. But 30 and 40 years ago was something else going on here. A former student wants to sue the school for sexual abuse, but state law stands in the way. Charitable immunity, even in cases of child molestation. That's next on this edition of Due Process.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, a private foundation focusing on New Jersey public policy issues. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.
It's a statute that most New Jerseyans may never have heard of, might even be shocked by, but it's been the law since 1958. I'm Raymond Brown, and it's called Charitable Immunity. It protects churches, charities, private schools from lawsuits, even in cases of child sex abuse. We'll hear from the assemblyman who wants to end the immunity, from the former counsel to the Newark Archdiocese, and from a Rutgers law professor to put it all in context. But first, here's Sandy King with one man's fight for the right to fight back.
Raymond, his case is not so different from others who say that as children, they were sexual victims. Victims of priests or coaches or teachers. But this man's tenacity, his insistence that his charges be heard, could change New Jersey law. And if he does, it could mean a day in court for every adult who says he is haunted by childhood memories of abuse.
As a child, I was sexually molested by my parish priest over a number of years.
It was a horrendous place where literally scores and scores of kids were sexually abused day and night.
He was repeatedly raped and sodomized by the musical director, by the headmaster, by the proctor in charge of discipline, and even by the cook.
They are the kind of hair-raising stories that might logically lead to a courtroom, to a judge and a jury, to a civil suit and a verdict.
They deserve their day in court. They deserve to be heard.
But not in New Jersey, at least not on the civil side, where a nearly 50-year-old immunity law protects nonprofit institutions like churches and this private school from lawsuits, even in cases of child rape and molestation.
All I want is to be able to present my case before a jury and let a jury make a determination about the responsibility and liability of the institution.
The institution in question, the American Boy Choir School. By the time of this performance in 1997, there were safeguards here against sexual abuse, policies established to protect boys like these.
We've had a rigorous program of child protection in place for at least 2 decades or more that I'm aware of. And the most important thing we do is to educate the boys about what constitutes abuse, what to do about it if they ever see any signs of it, and help them to learn how to protect themselves.
But in earlier years, the charges go, something else was going on here. sexual predators on the loose, it's claimed. Staffers who allegedly turned this boarding school into every parent's nightmare.
Literally scores of children were abused at the American Boy Choir over the course of decades, beginning in the 1950s, going through the 1960s, the 1970s, and through the 1980s.
That is John Hardwick's serious charge. But no jury will get the chance to hear it unless this court or the legislature, please be seated, changes the rules.
The duty that a school owes to its students to protect them from this type of abuse is fundamental. If not in a case like this, then in what sense is that fundamental duty protected in the state of New Jersey?
That question put to the state Supreme Court by a Stanford law professor, himself an alumnus of the Boy Choir School.
There's no reason to believe the New Jersey legislature intended to immunize charities or anybody from responsibility for sexual abuse when New Jersey has been so good in attempting to remedy the extraordinary problems that sexual abuse create.
The kind of large settlement or large judgment that Mr. Hardwick is seeking could have a very negative effect on us, and ultimately the people who would pay the price are not the people who were around in 1970.
Although some horrific things were done 35 years ago, it's not the greatest concern. There are other areas of concern.
Concern shared by an institution with potentially the most to lose if the court should rule that John Hardwick and others like him can have their day in court.
One of the briefs filed in this case was filed by the Catholic dioceses, and that brief basically supported the idea that the school would be absolutely immune from liability for intentional, pervasive sex abuse by the teachers.
My name is Gregory Gianfrancaro, and I'm an attorney representing over 30 victims of clerical abuse within the state of New Jersey.
Victims with stories like Mark Crawford's. His claim that after years of abuse by his parish priest,
they said, look, you just stay away from him, he's going to stay away from you. They left him right in my parish for another several years. Nothing happened. Eventually, he was promoted, became the Archbishop's personal secretary.
But Crawford says when he threatened to sue,
I was also told, gee, we have immunity due to charitable immunity. You'll really get nowhere. Take this little bit of money and go away. And I was devastated by that kind of response.
So Crawford not only has his eye on the court, he's also with Hardwick on another front, lobbying the legislature to end charitable immunity in cases of child sex abuse, and to do it retroactively.
To change the rules now, 30, 40, 50 years after the fact, makes it very, very difficult for an institution, a charitable institution, to defend itself.
But don't tell that to John Hardwick.
And if I could spend maybe just 5 or 10 minutes with you talking about the legislation and where it stands.
Where it stands is that it passed the Senate last September, but there's been no vote in the Assembly, though there is bipartisan support.
I'll tell you what we need to do. We need to go to the leadership of the Assembly and bang on their desks until they listen and post the legislation.
After hearing the stories such as John's and others, and the victims who are out there who have really no recourse, I feel it's important. I feel New Jersey needs to pass this law.
I go to bed at night praying that the next day, that tomorrow, the Supreme Court will rule in favor of victims. I wake up in the morning praying that the legislature will pass a law to end charitable immunity. And every day that goes by is another day that victims in the state are denied justice. Every day that goes by is another day that we're betrayed by the state of New Jersey.
This is not the first time that the state Supreme Court has looked at charitable immunity. 20 years ago, it upheld the shield in the case of child sex abuse by a church employee. But 2 decades later, it's a different court and a different legislature. And if either overturns the shield, New Jersey could move into the mainstream. This state, now one of only 9 that still protects charities and churches from lawsuits.
And when we come back, we'll get the arguments for lifting the shield and keeping it. So stay with us.
I'd like to think, and I hope, that it's not all that pervasive. I think that the stories, as horrific as some of them are, tend to get blown out of proportion.
It's rampant because a lot of it is not being reported. A lot of it is going undetected.
I think people are really clamping down on it. I think it did happen in the past rather significantly, but I think everybody's afraid of all the civil suits and everything else coming after people now.
You hear about it in the news an awful lot. I guess I hope that with parental involvement and constantly talking to kids, your kids, back and forth, you know, those types of things are minimized.
I mean, come on, give me a break. It's a situation where the children should feel safe and secure, not where they got to fear about going to school or going to church, whether they're going to be assaulted or abused by their elders.
About that every day.
And so it's universally agreed. Child sex abuse is an inexcusable offense. But whether individual cases, especially ones that are decades old, should lead to lawsuits and large cash awards, well, that's where the dispute comes in. For some insight from both sides, we turn to Assemblyman Neil Cohen, sponsor of the bill to end the shield, from William Cambria, who for 19 years handled legal affairs for the Newark Archdiocese. And with us in Newark from Rutgers Law School, Associate Dean Bernard Bell, a specialist on torts and New Jersey law. Welcome to all of you.
Thanks for the invitation.
Thank you. Neil, let me start with you. The question of child sex abuse against either people in the church or schools is not a new one. We've had really a decade of continued debate. Why is the legislature acting now? I mean, we know there's been the American Boy Choir School issue that's before the state Supreme Court, but why did it take that to get the legislature moving?
Well, you know, the legislature is basically reactive. And for many years, once the Schultz decision came down by the state Supreme Court, the legislature really took no action, even though the court then said you need to legislate this and resolve the type of problems that exist in the system regarding sex abuse. Legislature never moved. Once more cases started coming out, situations that happened in Boston and in New Jersey and some other areas, Senator Vitale on the Senate side, who's sponsoring legislation with Senator Gill, and myself and Assemblyman Bateman and some others on the Assembly side decided that now was the time to deal with all these issues. And that's how the legislation got redrafted again.
But it was precipitated, at least this current round of passage in the Senate and deliberation in the Assembly by the American. All right. That brings me to you, William, which is the question of whether or not you agree with the momentum in the Senate and the Assembly that seems to be saying we ought to take charitable immunity away from institutions like the church in particular, which is profoundly interested in this question.
Well, I don't think that the legislature ought to move in that direction. And in fact, they have not been moving in that direction in the last 20 years. Neil mentioned the Schultz case that was decided 20 years ago. In fact, since then, the legislature has increased the amount of immunity that's available. They did that with respect to Little League coaches and with respect to first responders for accidents, and they've also increased the amount of immunity that's available under the charitable immunity law for churches and other types of charities. So this is, in my view, at least, pretty late in the game to be trying to do this. Because
but the focus here is whether child sex abuse is different from other kinds of...
Let me just say, Bill may be correct in terms of those immunities, but those immunities had nothing to do with sexual assault, so that everyone understands this limitation and stripping away of charitable immunity only applies where there has been sexual abuse. New Jersey is really a dinosaur nationwide. 50-something states or less have already done away with charitable immunity, not only as to sexual assault, but I think it's 43 states have completely stripped away charitable immunity, whether it's a slip and fall, whether it's bad food, whether it's sexual abuse, or whether it's some other kind of activity.
Bernard,
we are behind everyone else.
I'll come back to you, Bill, in a second. But Bernard, Bill, let me put this in context. Neil mentioned that we're one of only 9 states that has charitable immunity statute like ours. Why is there a shift, and is New Jersey really on the tail end of a movement, at least in child sex abuse cases, away from charitable immunity?
Well, it's the tort law in general has been moving toward expanding liability and getting rid of traditional common law doctrines that have provided immunities to particular actors. So in the last 50 to 60 years since the 1950s or the 1960s, there's been an elimination of things like governmental immunities, so governments are much more liable for torts.
So you're saying
now.
This is part of a broader trend. Let me ask you to focus then on the question of whether child sex abuse, which has had a special amount of attention in at least the criminal justice system in the last 20 years and a corresponding increase in focus in the civil system, whether that's an area where the movement is even faster.
I'm not sure about that. I'm not sure I can characterize the movement with regard to child sex abuse, but I certainly think that in general, the law in many ways has gotten much more conscious of child sex abuse and much more vigorous about dealing with it.
Right. Bill, let me come back to how we come to be here today, which is that the appellate division, one step below the Supreme Court, basically held in an opinion that, in fact, charitable immunity would not protect the American Boy Choir School. And the possible implications of that were broad, but it specifically looked at the gravity with which we've all, as a society, and the state legislature in particular, has treated child sex abuse. What's the key argument which would be made on behalf of those who say, look, both in the Supreme Court and in the legislature, there ought not to be a lifting of charitable immunity in this most egregious area with respect to conduct?
Well, without getting too technical, my understanding is that the Boy Choir School case has some unique factors with respect to the fact that it was a boarding school. And the children were actually living on the premises there. And you know, to get back to what we talked about before.
But there is a sense that it has broader implications. The church, for example, filed a friend of the court brief, obviously sensing that the Supreme Court, if it rules, is likely to rule in a way that isn't just restricted to American Boy Choir circumstances, but might affect the church and other institutions with charitable immunity.
Well, that's always a possibility, but I do think that it's an important issue to charitable groups, and it would not be surprising to see that they would file an amicus brief. But to get back to something we were talking about before, the legislature did act with respect to sexual abuse back in 1992 when it enacted a law that expanded basically the statute of limitations for bringing such claims. So this is not something that is only being thought of by the legislature now. They have considered this and they have acted, as I said, 13 years ago with respect to this particular issue. Now, they didn't address charitable immunity at the time, but they did focus on the problem. Part of the benefit of litigation in our society is that it helps to bring about change. And over the past 20 years, I think we've seen a tremendous amount of change about how churches and other charitable groups respond to the problem, the potentiality of child abuse. And I think that with the steps that have been taken in the intervening time, there is very little that could be criticized in the way that churches and other charitable groups handle their hiring practices, their protection of children today. So in terms of seeing litigation as a vehicle for accomplishing something that would add to the protection of children today, that's not there. What we're talking about, let me finish this one thought. Sure. What we're talking about is having churches and other charitable groups have to dig into the assets or the resources that they have that could be used to benefit people today and have to divert those assets into paying for things that happened many, many years ago.
That's a false issue. The charitable immunity bill that we're dealing with only deals with sexual abuse. It doesn't deal with the other areas of immunity. There has not been a problem in the other 42 states who completely abolished all immunity. They still have churches, they still have synagogues, they still have Little League, they have no problem finding volunteers, and they have no problem finding insurance. That's a misleading issue.
Let me put the question in a tough way, because I think Bill raises an important question. Let's take the American Boy Choir School case. Okay. It seems that we get the sense that there may be a number of cases that might come if the Supreme Court says charitable immunity doesn't apply. And while the church is more difficult to calculate because it's a larger institution, at least no one could say without reason that the American Boy Choir School and maybe other small institutions like it, even though you might be satisfied that they have cleaned up their act and are protecting children.
They wouldn't have cleaned up their act, Raymond.
Just let me finish the question.
You got
to let me finish the question.
Okay.
Let's assume that you were satisfied that the American Boy Choir School has reformed completely, but that behind this case lie a number of cases that might wipe it out financially. I mean, and the purpose of charitable immunity was initially to protect such institutions.
First of all,
Tell me,
I don't know what their assets are.
But just
I don't know
assume
how
that.
much. I
Assume
can't
that.
assume
All right.
that
How about an
litigation is
XYZ?
going to wipe them out.
Okay.
They have insurance. They have reinsurance. I don't know what their assets are.
Okay.
But it's kind of like, well, we destroyed your children. We probably destroyed a number of generations. But don't hold us responsible, because you know what? It may cost us some money. And I can't argue that in the abstract of knowing what their assets are. What I do know is that in 42 states, it's somehow all these organizations manage to take care of their problems without any charitable immunity even existing. And now turning on the victim and saying, you know what, I know we victimized you.
Let me ask Bernard Bell. The sense here is that there is at least a theoretical question about whether we should be concerned about fiscal soundness if the conduct is so egregious. Is that one of the issues that underlies this discussion, Bernard?
Yes, I mean, I think there are really two issues here. One issue is charitable immunity and whether it should continue or not, particularly going forward. The second issue, which has kind of gotten tied up in this, is a question that's had come up often in torts these days, which are situations where you have action that takes place at some point and then a lengthy time thereafter, the harm manifests itself. And then in that situation, I mean, that's a tough situation to deal with regard to how do you compensate victims in a way that doesn't completely upset reasonable expectations of the entity that's acting. So I think we have to be careful to separate those two issues. That sort of issue comes up, for instance, in the asbestos litigation and a lot of drug litigation where you've got long latency periods. And so I think this is a similar situation.
Let me make sure that I'm glad you said that you put this word on the table, retroactivity. Your bill would presumably say that you're not going to provide protection going forward in child sex abuse cases, but also that immunity from the past would be stripped away. Is that true?
No, it isn't. It isn't.
Okay.
What it says, what the bill says, is that for those cases that have not yet been adjudicated, where claims have been filed, and for those cases that are still pending in the court, wouldn't apply those cases that have not been filed, that are beyond the statute of limitations. It would apply to those cases currently pending or not yet adjudicated and then forward. So we're not bringing in 6,000 cases from the past. We're dealing with those cases that are currently pending or not yet adjudicated that would apply, that would talk about negligent hiring, protection of those who are sexually assaulting others, stripping away, being responsible for an intentional tort.
Right. Putting aside the broader issues of charitable immunity, are you concerned about retroactivity as a part of this discussion?
Well, yes, and I think a point that Neil made a few moments ago is very important. In other states where there is no charitable immunity, Neil points out, they have insurance, and if anything happens and they are sued, they have insurance available to cover it. And if the New Jersey legislature were to pass a law today that said there's no charitable immunity either for sexual misconduct or for everything today going forward, then churches and other charities could insure themselves. It would cost them some money, and they might have to give up a program or two, but they could do it. They could handle it. But if you go back 25 years or 30 years, when charitable immunity was the law, insurance coverage is not in place for those times, so that if there are large awards, they're going to come out of the resources of the charity, not from insurance companies.
We're running out of time, so I got to get a prediction from each of you. Neil, is your bill going to pass?
The bill is going to pass ultimately, hopefully at the end of this year.
And the Supreme Court, how will it rule?
I feel that you never tell, but I think the Supreme Court's going to find on the side of the victim.
I know you can never tell, Bill, but how's the Supreme Court going to rule?
Well, I don't know how they're going to rule, and I wouldn't hazard a guess, but I do think that it's an important case because it will define charitable immunity going forward.
Bernard, you got 10 seconds. Tell me how the Supreme Court's going to rule.
I hesitate to guess either, but
anyway.
But I would guess that the court will say that charitable immunity does apply.
All right, well, we'll have to come back and have further discussions on this because that's it for this edition of Due Process, with our thanks to Assemblyman Neil Cohen, to William Cambria, and to Dean Bernard Bell. But we'll be back here next week with more in-depth examination of law and justice issues. Till then, for Sandy King and all of us here, I'm Raymond Brown. Thanks for watching.
Evidence in this case will suggest between 30 and 50% of the boys at this school were sexually harassed and abused by the institution. Sex abuse had been institutionalized at this boy choir school.
That might be personal knowledge of Mr. Lessig, but it hasn't been in the record of this case anywhere that 30 to 50%. It started off with 2 or 3 or 5 or 6 or 7. It got up to dozens, and now it's 30 to 50% of the student body.
With all due respect, Mr. Greenblatt, someone as infamous as Joseph Stalin once said, one death is a tragedy, a million deaths is a statistic.
I understand that.
How many more do we need than one?
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, a private foundation focusing on New Jersey public policy issues. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.